By now you understand that not every promise is binding. Continuing on with the subject of contracts, when a promise is binding, this lecture is going to focus on consideration. The first concept you should understand about consideration is that it means something of legal value. It can be difficult to understand that a promise has legal value as consideration, distinct from the economic value, if any, of a thing promised. The thing of legal value may be goods, money, performance, or a return promise. If it is performance, that performance must be an act other than a promise. A forbearance, refraining from doing something that someone has a legal right to do, or the creation, modification, or destruction of a legal relation. The second concept that should be explained is that consideration must be bargained for. Performance or a promise is bargained for if the promisor seeks it in exchange for his or her promise, and the promisee gives it in exchange for that promise. It is not enough that the promise induces the conduct of the promisee, or that the conduct of the promisee induces the making of the promise. They must induce each other. Or the bargained for exchange element doesn't exist. Consideration is the value given in return for a promise. As noted, it has legally sufficient value. Now, this can be a promise to do something that one has no prior legal duty to do. It can be the performance of an action that one is otherwise not obligated to undertake. And it can be the forbearance or the refraining from an action that one has a legal right to undertake. A bargained for exchange is the consideration given by the promisor that must induce the promisee to offer a return promise, a performance or forbearance, which must induce the promisor to make the promise. This element of bargain for exchange distinguishes contracts from gifts. Consideration is something exchanged for something else. Often, this concept is broken into two elements. First, to constitute consideration, a performance or a return promise must be bargained for. A performance or return promise is bargained for if it is sought by the promisor in exchange for his promise and is given by the promisee in exchange for that promise. The performance may consist of an act other than a promise, or a forbearance, or the creation, modification, or destruction of a legal relation. And the performance or return promise may be given to the promisor or to some other person. It may be given by the promisee or by some other person. In a bargain for, the consideration and the promise bear a reciprocal relation of motive or inducement. The consideration induces the making of the promise, and the promise induces the furnishing of the consideration. Here, as in the matter of mutual assent, the law is concerned with the external manifestation rather than the undisclosed mental state. It's enough that one party manifests an intention to induce the other's response and to be induced by it, and that the other responds in accordance with the inducement. But it is not enough that the promise induces the conduct of the promisee or that the conduct of the promisee induces the making of the promise. Both elements must be present or there is no bargain. A mere pretense of bargain doesn't suffice, as where there is a false recital of consideration or where the purported consideration is just nominal. In such cases, there is no consideration and the promise is enforced, if at all, as a promise binding without consideration. Here's an example of a bargain for exchange. A offers to buy a book owned by B and to pay B $10 in exchange. B accepts the offer and delivers the book to A. The transfer and delivery of the book constitute a performance, and are consideration for A's promise. This is so even though A, at the time he makes the offer, secretly intends to pay B $10 whether or not he gets the book, or even though B, at the same time he accepts, secretly intends not to collect the $10. Adequacy of consideration refers to the fairness of the bargain. Ordinarily, courts will not evaluate the adequacy of consideration regardless of the comparative economic value of the things exchanged. Parties are generally free to bargain as they will. The general rule is that if there is consideration, then the adequacy of the consideration will not be reviewed. What this means is that as long as the contract is not unconscionable, the courts will not consider whether a bargain for promise or performance is equal in value to the counter promise or performance. Essentially, the courts believe that the parties to the contract are in the best position to determine its fairness. Under most circumstances, a promise to do what one already has a legal duty to do, such as a pre-existing duty, is not legally sufficient consideration. Now, there are some exceptions to this. Unforeseen difficulties is when a party to a contract runs into unforeseen and substantial difficulties that could not have been anticipated at the time the contract was entered into. The parties may agree to extra compensation for overcoming the difficulties, and a court may enforce the agreement. These unforeseen difficulties do not include risks ordinarily assumed in business. Rescission and a new contract are when two parties can agree to rescind their contract, at least to the extent that it is executory. When rescission and the making of a new contract take place at the same time, some courts may find the pre-existing duty and refuse to enforce the new promise. Past consideration. Promises made with respect to events that have already taken place are unenforceable. They lack the element of bargain for exchange. Past consideration is no consideration. When an individual is already employed, his or her employment is not sufficient consideration for a newly signed non-compete agreement. To be valid, the agreement requires new consideration. There are problems with consideration. One is an illusory promise. If a contract expresses such uncertainty of performance that the promisor has not actually promised to do anything, the promise is illusory, without consideration, and it's unenforceable. An option to cancel clause that allows the promisor to cancel the deal before performance has begun creates uncertainty of performance and is illusory. A settlement of claims. A release bars further recovery. A release is binding if it is secured and given in good faith. It is in a signed writing, which isn't always required in all states, and consideration is given. There is a covenant not to sue. Unlike a release, a covenant not to sue does not bar further recovery. A covenant not to sue is binding if it is secured and given in good faith, it is in a signed writing, and consideration is given. Promissory estoppel. Reasonable reliance on a promise may form a basis for enforceable contract rights and duties under the doctrine of promissory estoppel, or sometimes we call it detrimental reliance. If there's a clear and definite promise, the promisor's expectation that the promisee will rely on the promise, the promisee's act or refraining from acting in reasonable reliance on the promise, and the promisee's definite reliance results in substantial detriment. Justice better served by enforcement of the promise. So here's an example for you. Daffy's family is starving, and Daffy desperately needs a loan in order to feed his children. Daffy goes to Bugs and asks for a loan of $1,000. Bugs promises to lend Daffy $1,000 if Daffy promises to return the $1,000 along with $750 in interest. Daffy agrees. In this situation, there's consideration. Bugs has promised to loan Daffy $1,000 as the price for receiving Daffy's $1,750 in return, and Daffy's promised to give Bugs $1,750 in return for Bugs' promise of a $1,000 loan. Typically, adequacy of consideration would not be reviewed, but the courts will review adequacy of consideration if they feel that a contract is unconscionable. It's arguable that a court in this case would review the adequacy of consideration, since it is certainly reasonable to say that a contract calling for a borrower to repay a loan along with a 75% interest is unconscionable. Here's another example. Michael promises to give his brother Scotty a new $50,000 Mercedes in exchange for $5. Neither Michael nor Scotty consider the $5 as payment for the car. Rather, they have exchanged a promise for the car for a promise for the cash in order to create consideration and make Michael's promise enforceable. However, because neither Michael nor Scotty consider the $5 as the price Scotty has to pay for the car, this consideration is nominal only. Now note that if Michael and Scotty had intended to make a bargain so that Michael considers the $5 as actual payment for the car and Scotty considers the car as what he was receiving for his $5, the court will find this to be proper consideration no matter how disproportionate the consideration seems to be. Although the general rule is that nominal consideration will not make a promise enforceable, it will make options and guarantees enforceable as long as certain conditions are met. A bargain for promise to surrender or forbear from asserting a claim that is reasonable and held in good faith constitutes consideration. So, for example here, Jerry crashes into Edie's front porch and promises to pay her $1,000 in exchange for Edie's promise not to sue Jerry. Her promise, along with Jerry's promise, will constitute consideration because Edie's legal claim is reasonable and held in good faith. However, problems arise when a claim is not reasonable or held in good faith. So, for example, a promise not to sue when a lawsuit would be frivolous in the first place. The general rule is that a promise to surrender or forbear from asserting a claim is consideration if the promisor's belief in the validity of the claim is either reasonable or held in good faith. Now, an illusory promise, like nominal consideration, looks like a contract and sounds like a contract, but it's not a contract because one of the parties is not bound. As we said, in order for a bilateral contract to be enforceable, it must have mutuality of obligation. Because an illusory promise forms a contract in which only one party is required to perform, an illusory promise is not valid consideration, and neither party to a contract containing an illusory promise is bound by the contract. The illusory promisor is not bound because he has not made any kind of commitment. Nothing he has promised actually limits his future options. The real promisor is not bound because he has received an illusory promise in exchange for his real promise, and since an illusory promise is not consideration, no enforceable contract has been forged. The general rule is that if one party makes an illusory promise in exchange for someone else's real promise, neither party is bound. There are two kinds of illusory promises. The first is where the promisor promises to do something only if he wants to. Here's an example. Sunshine Orange Groves and Squeeze Me Juice Company enter a contract where Squeeze Me will buy all the oranges it needs from Sunshine, and Sunshine will sell all the oranges it wants to do to Squeeze Me. This promise is illusory because while Squeeze Me is bound, Sunshine is not. Squeeze Me is bound because although nothing in the contract stipulates that Squeeze Me must buy oranges, if they choose to buy oranges, they can buy the oranges from Sunshine. Thus, Squeeze Me has limited its future options. However, Sunshine has promised to sell as many oranges as it wants to Squeeze Me. Thus, if Sunshine decides they don't want to sell any oranges to Squeeze Me, they don't have to, and they can sell oranges to whomever they want. Sunshine has not limited their future options and is thus not bound by anything. Therefore, that contract wouldn't be enforceable. Well, what about Sunshine Orange, Groves, and Squeeze Me Juice Company enter into a contract in which Squeeze Me promises to buy all the oranges it needs from Sunshine, and Sunshine promises to sell all of the oranges it grows to Squeeze Me. Now we've got a valid contract because both parties are bound. Although nothing in the contract stipulates that Squeeze Me must buy oranges, if they buy oranges, they must buy them from Sunshine. And although nothing in the contract stipulates that Sunshine must grow oranges, if they grow oranges, they must sell those oranges to Squeeze Me. So there you have it. We've gone over some of the items of consideration, and feel free to review this as often as you need so you can grasp this concept.